Okay, so just generically speaking, right? Your background, you're liberal to progressive, and you and I, we just sort of kind of ran into each other, just some back and forth Twitter stuff. It's pretty clear to me that your political ideologies bring you around to a point that you believe that you believe in redistributive economics, that the government exists to try to facilitate the greatest amount of good amongst the greatest number of people. I'm not saying that that's necessarily a bad thing, but there's this thing that I refer to as the Constitution. A lot of people believe that the way we do things has to comport with law, and the source of our laws all stems from the Constitution. So there's a lot of things that a lot of people with your political persuasion would like to be able to do doesn't easily fit within the construct of that Constitution, so it needs to be changed. And instead of changing it, there's a lot of machination that goes along that people do in order to get that, to get what they want. So I think you kind of understand what I am and who I am based on our Twitter back and forth. We've gotten some, pretty in-depth stuff back and forth on Twitter. So I wanted to just give an opportunity to sort of go back and forth over like positions and see where we can possibly find some common ground.
Yeah, I actually think that your characterization of my position is probably fairly accurate, if not surface level. I would like to caveat that real quick and say that I only support the greatest amount of good for the greatest amount of people up to a certain point. There are some like hypotheticals you could give to me where I would be like, no, that's probably not a good position because of this, that, or the other reason.
Okay, well, let's kind of dive into it a little bit. Some of the controversies that you and I have been involved with on Twitter. What's one that jumps right out at you? And let's just sort of dig into the meat of it.
Well, I do. While I usually do like political position conversations, I think that the more interesting conversation between me and you is probably going to be like a broader political philosophy conversation, just because I believe that anything that I'm going to say, you would probably be able to, if you disagree, it's probably going to be on the constitutional basis, and that's just going to be the end of it. If you would prefer to have the policy conversation, I can. I came into here expecting like to talk about like constitutional conservatism a little bit, and then we can jump into like more policy positions if you'd like.
Well, that's fine. I mean, constitutional conservatism. People look at like conservatives and say, well, you want to go back to the 1800s. You want to go back to the days of slavery. That's not true at all. The Republican Party has never been in support of slavery. It was created to resist slavery. It was the party that ended slavery. It was the party that ended Jim Crow. It was the party that afforded more people of diverse backgrounds opportunities to be successful and achieve in society. Now, yeah. It doesn't mean that there aren't corrupt people, right? That there aren't people who are racist, people that don't like people who don't look like them. That's true, and that's true of all groups, right? There's plenty of racists in the Democratic Party as well.
So yeah, I don't think that you as a constitutional conservative wants to go back to the days of slavery, because like abolishing slavery is in the Constitution as far as I know, correct?
Yeah, but this is an argument, right, that a lot of people on the left, and you to be fair, you've not advocated that conservatives want to do this, right? That a lot of people on the left have. So this is not really the foundational argument, right? That I think that we're going to engage in, because neither one of us believe it to be true of the other. Fair enough?
Yeah, no, I don't think that you want to go back to the days of slavery. I mean, I think that the point that I can derive from that statement is that, to me, it seems like constitutional conservatism, it does harp on a lot of a lot of concepts and beliefs and values from old times that may not be like valuable today. I don't really have any specifics. I would have to. The reason why I want to have this conversation is I don't look to come away from here with like a. I'm not trying to like debate or push back right now. I'm just trying to get a better understanding of the concept and what you believe.
Sure.
And then as I think more about it, I may have like specific pushbacks that I may come back on to talk about.
Sure. I you know, let's take just a kind of an example, right? A constructionist or an original intent person who looks at laws that Congress passes or that the federal government passes or that any government passes, right? Because of the supremacy clause, all state laws have to be subservient to the Constitution, right? When we talk about the laws that get passed, just because the law, now we infer that laws are constitutional by their existence unless they're challenged, right? Unless they're overturned, adjudicated and overturned by a court. Ultimately, depending on the level that you wish to pursue it, up to the level of the Supreme Court. And where cases don't make it to the Supreme Court, you can have one district, one circuit say one thing about a particular position constitutionally, and another circuit will say a different thing. So they would be in conflict. And that's when the cases generally tend to rise, most of the time tend to rise up to the Supreme Court. The Supreme Court then seeks to try to interpret using one of a couple primary methodologies. One is the living, breathing Constitution, that we need to infer the changes of society today mean that we must redefine certain things about the Constitution, its clauses, and the amendments in order to make it workable. And then there's the other side, the side that I happen to be on, which is constitutional constructionism. I want to be careful not to say conservative, because conservative is a political ideology, whereas constructionism is a philosophy of application. So we look at the under original intent or constructionism, we look at the Constitution as it was written. The words mean what they say they are, and you can use the additional background information about the discussions, the debates, and the so forth and so on that went on during that approval process, during the amendment approval process, or the passing, the ratification of the amendment, and then being ratified by the 3/4 of the states as they existed at the time that it was foisted upon them. And a good example is the 14th Amendment. The 14th Amendment was meant to apply solely to anybody who had been previously a slave, because after the 13th Amendment, a lot of governments in the South were mistreating slaves. They were making the poll taxes, the original Jim Crow laws and things like that, right? They were making it very difficult for blacks to be able to vote. And they were doing everything they can to prevent them from receiving all the rights and benefits of a citizen. And the 14th Amendment was passed exclusively to be able to say, no, anybody, regardless of their previous condition of servitude, who is a citizen of the United States is entitled to all of the benefits therefore provided under the Constitution by all the other amendments. So it was sad that the 14th Amendment had to be done, right? But it was there because what was in the Constitution wasn't clear enough. Okay, it wasn't clear enough, so it had to be foisted back out to say, no, this is correcting a problem. And enough people, enough legislatures in the Republic said, yes, we agree with that. And then they ratified it. And that's the process that you should do. It's not to say that the Constitution's a perfect document, right? We seek to create a more perfect union. The name of the show is The More Perfect Union. We're not there yet. We want to get there, but we all have to get there through consensus and through working together about things that are broad spectrum problems. And the constructionist says we need to look at the Constitution. Our laws have to fit within the framework of the Constitution. And if we have a problem that the Constitution doesn't solve, and this gets more to your point about like, well, we did something. Hey, what's up, Bandit? Thanks very much. Appreciate that subscription there. 10 months in a row. I appreciate it, man. When we look at being able to make those modifications, right, they're in response to a condition that we all, like the massive majority of the nation says, that's a problem. And the converse side of that is that people think, especially since the early 1900s, after the Fed, 1913, the 15th Amendment, the 16th Amendment and the 17th Amendment, that the federal government began to take in large amounts of money, and politicians tending to what politicians generally do, which is tend toward corruption and personal aggrandizement and graft, they sort of figure out that they can vote themselves out of the people's treasury and that they can bribe the voters with their own money. I mean, Tocqueville said it best in Democracy in America. He said, democracy will not long last in America. I'm paraphrasing. Democracy will not long last in America once the legislators realize they can vote themselves or they can bribe the people with their own money. And this is what we've had since primarily 1916. And it's terrible. It's terrible because most of the promises that we get in order to secure political power are not financially viable. And they require an ever larger share of money from an ever smaller group of people in order to keep an ever larger group of people minimally placated, right? Income inequality exists in this country because we have, we have made it possible for people to live on the most meager of existence. Well, if you get comfortable living on welfare, you are not getting ahead. You are by definition standing still or falling backward, right? Because you're not generating wealth. You're not saving money. You're just trying to hang on to what you've got to whatever you're doing. That actually leads to things like higher crime rates, right? Alternative sources of income, like, say, drug trade or whatever, right? And then the people who are working, and I'm not talking about like the ultra rich. I'm not talking about the Elon Musks of the world. There's not that many of those guys. Yeah, they have a lot of wealth, but they built a better mousetrap for the most part. Okay? But these people, we're talking about like middle income average people in the United States, if they can just sort of plan out, for the most part, if they can just plan to live within their means and cut back just a little bit and then take that money and do something productive with it, some kind of an investment, some kind of savings, until you get to a threshold, and then you can invest in something. Or you're working in a factory job for 15, 20 years, and then you realize one day that, hey, I can do the thing that this thing is how this is being made, and my company's not listening to me. I can make that better. And then you strike out on your own. Hey, AOD, what's up, brother? So it's that kind of an opportunity that the Constitution we have today provides. It's what the founders wanted us to have, and they made it difficult to change because they felt that you needed a stable platform of law and a rule of law to operate against so that you could actually get to the point where this country could afford the most opportunity it could at the least impinging point of contact. The original intent of the Constitution was that we would have a central government that was relatively weak. It focused on just a very few enumerated or specified powers and duties, and everything else would be reserved to the states. Okay, and if it wasn't defined to the states, then it was freedoms that were inherently prescribed to the people. And your point when we were talking at the beginning, right? This is this kind of a circuitous thing, but to come back to your point when you said that when you said that when people are trying to hold on, I've kind of lost my train of thought for some odd reason. When people look back into history, the Dobbs case, right? This became manifest up into the public view when the Dobbs case was decided, and everybody railed on Samuel Justice Alito and his argument where he says, well, we reach back into the time in which the amendment, the 14th Amendment, because that's where Roe derived its authority incorrectly. Even Ruth Bader Ginsburg said it was improperly decided, or it was faulty legal logic, right, in reasoning. But when you go back, if you are trying to be a constructionist, you're looking at the law, you're looking to say, okay, was there an enumerated power that said the federal government can grant the right to have an abortion? And there was none. As a matter of fact, abortion was illegal in the United States long after, in every state. It was illegal long after the 14th Amendment was ratified. Okay, so if it didn't exist as a common practice at the time of the 14th Amendment, that's where you can say, okay, you can infer that, yeah, it does cover this because it existed at the time. But there was no federal law that allowed abortion. And there was no state laws. There's nothing that prevented a state from allowing or disallowing it. Okay, and it had never come up before the courts. So in the absence of any prevailing law, you go back to what existed at the time, and if you don't see anything that existed at the time, then you reach back, for lack of a better word, into antiquated British common law, because that's where all of our laws at the founding of the United States, all of our laws that were not expressly stipulated in the Constitution, are all reserved under English canon law or common law. So when people, got their tits in a wrench over, Alito looking back into antiquity and looking at 1848, okay, he was doing what he should have done. He was following a prescriptive process. And at the end of the day, the Dobbs decision didn't invalidate the right to have an abortion. It just returned the decision to the states. And as we have seen thus far, there are states, mostly liberal, that are not only just, providing opportunity for abortion, but they're paying for it. And they're being even less restrictive than what the rules were under Casey. And that's up to those. I personally, I don't agree with abortion. I think it's very problematic from a moral perspective. But I also believe that the states have their right to decide. The voters of each state have a right en masse to decide what they want to do. And then they can elect officials who will pass a law that allows, restricts, or eliminates as they see fit. And that's what the Dobbs decision did. And that's why I think we need more of that to allow people to do it. And people will say that the Dobbs decision, because of some rhetoric that Clarence Thomas put in, because the question of a substantive right versus an enumerated or specified right was really kind of the argument that he was making. And everybody just went, tits in a ringer. It's going to be terrible. It's going to, they're going to outlaw gay marriage. They're going to outlaw this, that, and everything else. They're not going to do that because it would harm too many people who are married, right? My personal belief is the government ought not be involved in marriage at all. What two people wish to do, two consenting people wish to do with their life, the government should have no say in what that is. And I think it's a throwback to old religious times, like the Catholic Church and and other, other times, right, where where the church recorded the number of people who lived in a family so they could figure out really how they were going to tax them, right? The Catholic Church was a government entity, still is, right? At least in Rome, and there's a religious authority, and they want to know who's a member so that they can figure out, okay, what is the potential revenue stream they can get off of people. All right, I'm not being anti-Catholic there, but the original thing where the government tracked who was in a family was largely so that the church could figure out, where their wealth was going to be built at. So get the government out of church as well. I don't care if gay people want to get married. I don't care if people want to have gender reassignment surgery. It's not for me, but I don't give a shit. If you want to have it, right? A person wants to have it, let them have it. And should people be respected as people? Sure, they should. So long as they're civil and courteous to other people, I have no problem affording anybody respect. And I'm one of these constructionist guys, man, that on the social side of things, if you're not in my grill with it, I don't care. Live and let live. I'm a big fan of that. But there are people who are not exactly like that. There's a lot of those people that happen to be in the Republican Party. It doesn't make them bad people just because they're living their life according to a faith that they preach. And it's wholly inappropriate for the government or anybody else to tell these people that their religion is wrong. I'm not a big fan of Islam, but as long as they're not out there advocating for the slaughter of innocents, but I don't care. Catholics were responsible for the Crusades. Horrific. Right? We're not doing it today. Do we have to say that it's okay for every religion that sprouts up, that they have the same 1,400 year lag time that they get to experience all the death and dismemberment of anything else? Is it okay? Should we not be calling out like ISIS terrorism and Al Qaeda terrorism? Of course we should, because it's anti-human. But anyway, that gets a little further afield from what it is. But my political philosophy says everything we do in this country has to be anchored in the rule of law. The rule of law as it sits today is the U.S. Constitution. And to the extent that politicians, legislators, and the administration at whatever level of government don't adhere to the principles contained within that document, then I have a problem with it, whether I agree with the policy or not. Right? I can, if it's constitutional, I disagree with the policy, I can lobby my representatives to try and change it. All the way up to and including a constitutional amendment, or advocating, as we're starting to see a lot of, which is the Convention of States movement, which is going to be a game changer. It's going to give everybody an opportunity to say, okay, 250 years has passed. Our document, if we think it's stale and outmoded, we have an opportunity to craft a changed document that will last us for another 250 years. But we have to be civil to each other while we try this out.
Okay. I guess my question would be, because you said a lot, and there's a lot I could push back on, but
push back on it, man. It's about it. Look, it's about a conversation, right? It's okay.
Remembering all that wasn't something I was gonna do in order to have this conversation. I want to go back to your political philosophy all the way to a broader strokes before we get into more of the nitty-gritty details. So I guess my political philosophy on the Constitution and stuff is that I think that the Constitution is a good thing for putting up boundaries for the government, but I think that sometimes those boundaries should be a little bit more fluid based off of the words of the Constitution. If you can interpret something in a way that allows something that would be good for the people, based off of what the people are voted on, as being constitutional based, then you probably should be able to do that. So my question for you would be, why do you think that a more rigid interpretation of the Constitution um, is more beneficial to the American people than a more fluid one?
Well, okay, so if you can redefine terms, then you're I don't know, for lack of a better analogy, I'll give you this one because I think it works well. If you build your house on a foundation of sand, your house is not likely to stand very long. Would you agree with that?
Probably.
Okay, so if your bedrock principle is a set of laws codified in a constitution, and you decide for expedient reasons that I want to change the way I think about this. This is how we've thought about it for this much time. It's been stable, but now we've come into a circumstance where we think that there's an issue here, and rather than change it, use the tools that are contained within it to change it, we just simply infer a different path. Like the whole question of substantive rights, right? This is something that Justice Thomas and Alito and others really have a problem with, because the fluidity of that leads to more confusion, much potential chaos, and then if you can change the interpretation because of a political party this way today, what prevents the other political party or a different political party from changing it back the next election cycle? And do you see what kind of chaos arises from that?
Yeah, so I would say that generally speaking, our systems are supposed to be representative of the people, the broader base of people, and there are roadblocks already put into place to keep something like what you just said from happening. So, for example, the Supreme Court's got lifetime appointments, correct?
Federal judges on good behavior have lifetime appointments.
Yeah, so I would imagine that that for the lifetime of your average judge, you would probably have generally a similar interpretation of what the Constitution means, up until the point that these judges end up dying and being replaced by a democratically elected body of government, which will replace them with people that are going to hopefully represent more of what the American view is at the time. And just that whole process would take so much time to change, that the fluidity that I'm talking about isn't going to be so breakneck like you're trying to make it seem.
1 second. So, is it your argument? Is it your argument then that the Supreme Court or the federal courts generally exist to make law? Like if something needs to happen because of an expedient reason, is it appropriate that the federal court system decide on their own volition, or take any case that comes before them and say, I think that this is a problem, therefore I think the law should be this?
So I don't think that they should make law. I think that they should use the words in the Constitution to interpret it in a way that fits today's society as best as possible.
Right, but
I don't think they should be making laws.
But that's what they did with Roe. That's what they did with Casey. No right prior for the federal government to say there is a mandated right under a really quizzical reading of the 14th Amendment's substantive right to privacy okay, was ever there afforded a woman the right to have an abortion through federal law. So they, in fact, did make law, and they make law all the time.
I'm kind of curious. Do you apply the same logic to something like the Second Amendment?
Second Amendment is a specifically enumerated right. It is a directed, specified, codified right.
It is, but if you look at the wording of the amendment itself, it seems to be like you can. All right, let me ask you this. My interpretation of what the amendment says, and don't get me wrong, I'm not anti-gun, but my interpretation of what the amendment actually says is that the right to bear arms is in service of the militia. And the militia can be, up until the Militia Act of whatever year it was, at the time of when the Constitution was written, the militia could have been anything that pretty much the state chose it to be. Is any of that wrong?
You're wrong, because what you've done is you've conflated the Second Amendment is a two-part thing. One is related to the other, but they're not intrinsically connected. So,
well, if that's the case, why was it written the way it was?
Well, you would have to go back in time, and you would have to understand how language operated at the time that the debates over the amendments were taking place. So give me just 1 second. I'm going to pull this up because I think it's an important point that you're bringing up, and I want to make sure that we cover it. We're very specific with it, because I want to answer your question, and there is a clean answer to your question. 1 second, please. Okay, let's see what we got here. Okay. So the Second Amendment says a well-regulated militia being necessary to the security of a free state. Part 1. The right of the people to keep and bear arms shall not be infringed. Okay? The right of the people shall not be infringed. So, let's see where we are here. See if we're getting back into our, there we go. Okay. So the right of the people to keep and bear arms shall not be infringed. So the militia was a state thing, okay, at the time and just after the Civil War. Okay, up until past the Civil War. Then after the Civil War, after 1900, we begin to see the concept of the National Guard, which is really a formalized version of the militia. Okay, where they had more training and this and that, everything else, whatever. At the time of the Constitution and the Bill of Rights ratification, every free person who had a firearm, and firearms were like a tool. They were like a Swiss Army knife back then, okay? Everybody hunted. It was an agrarian society. They had just gotten out of a war with England, okay? And we look at everybody as being participatory in the militia should something bad befall the town or the state or the nation, okay? Everybody, and there were actually in state constitutions at the time that said that every person should keep a operating weapon, should keep a certain amount of gunpowder and a certain amount of lead for shot handy at all times. They even prescribed the amounts. And what we have since the NFA in 1934 and the Gun Control Act of 1968, as it's been amended a few times, was that the exact opposite, that the government says you shouldn't have a firearm, or we should make it more difficult for you to have a firearm, not be infringed. Infringement, okay? This is it's explicitly stated, And there are people out there who hate guns, who think that we shouldn't have guns. We should be like Australia or, or other countries where they don't have any firearms. Well, that's okay. You can advocate that position. I'm not saying you are, but a person can make that avocation. Okay? If you can get 34 states to request it, you can do a convention of states. If you can get the Congress and the White House to sign an amendment with 2/3 majorities in both houses, you can send it out to the states. And if you can get 38 states, you can say the sky is purple. But until you change the Constitution, till you amend the Second Amendment or provide some other such amendment to the Constitution, everybody in this country has a right to keep and bear arms. And I will posit this. It's a hot take. But if you are a criminal and you've done your time, you should get your right to firearms back. Now, that goes against a lot of stuff, including Supreme Court precedents, which I happen to disagree with. There's two parts to the NFA, 1934. This is the law that was passed that outlawed automatic weapons after the St. Valentine's Day Massacre. If anybody wants to go back and look at history, it was mob boss type stuff. Okay. But if you think about it, and subsequently it's been found that Part 1 is unconstitutional, and I can't remember the entirety of it, but essentially the government said you could not register an automatic weapon after a certain date. And then the second part was that you had to maintain a license on the automatic weapons that you had. And what they did was they stopped funding the second part. They stopped processing the licensure. And when they did that, they basically made it impossible for somebody to be able to own a firearm, an automatic weapon, which it is possible still today to own an automatic weapon. So they said, strike down Part 1, it's unconstitutional. You can't tell somebody that they must do something and then fail to provide a path for them to do that thing. Hopefully, it looks like we may have lost him. Are you still there?
I'm still here. It's just the camera's acting up.
Yeah, okay, no problem. So you get what I'm talking about there, right? So yeah. So the Second Amendment, so to back to our point, the militia at the founding, or at the time the Bill of Rights was put together, was every free person in the country. Okay.
So where does it say that in the Bill of Rights?
You have to go back and look at the documentation and the debate that went around that.
So
everybody was considered part of the militia. Everybody.
So I don't know much about the Federalist Papers, but don't the Federalist Papers 29, doesn't Alexander Hamilton say something about the militia needs to be like an organized group and not just like every citizen?
Sure.
So wouldn't that be like evidence against the claim that everybody was in the militia back then?
No, the militia, because the militia trained and drilled often. If you go back and look at, like, you'll have to do some historical research. But there was a lot of history that people drilled in their local town militias. Okay, so you think, and a lot of people that are on the left-hand side of the argument think that the only militia that can exist has to exist under the auspices of governmental authority, and that's not true at all. That's why a lot of people hate this, and maybe there's some people out there kind of crackpotty, but there's a lot of well-intentioned people who are part of a militia movement who are not radical, crazy, going apeshit, trying to take down everything. But there are a lot. Bring it back in. Oh, there you are. There are a lot of people out there who believe that the Second Amendment and the primary reason for the Second Amendment is because They wanted people to be able to withstand two things: invasion from afar and tyrannical government at home. Okay? And when you restrict people's ability to own firearms, and again, my hot take is there should be no restrictions on firearms. You say, what about weapons of war? Well, people in revolutionary times, if you had enough money, you could own a mortar. Right? You say, what about automatic weapons? Well, I think it's called the Puckle gun. 1715 was a rapid fire musket. You could fire 63 rounds a minute. That was unheard of. The average, an expert sharpshooter with a musket could fire maybe 4 times a minute. It was potential for devastation. So, they knew these kinds of weapons existed. They'd existed for 80 or 90 years, and a lot of the mortar and cannon that were brought to the Revolutionary War were privately owned. So okay. I think a lot of people say, well, the militia, and I think your argument is largely posited against the fact that you believe that the National Guard is the militia today, that there can be no militia without the government instantiating it. And that's just simply not constitutionally valid.
So I understand that, like, that's the way it was, where people were training individually to become a part of, like, this larger militia as individuals, but kind of in a collective. But what I am trying to say is that if you're going to read the words of the Constitution and then read the Federalist Papers, which I think might be to most what I'm going to call constitutional constructivists, the Federalist Papers seem to be like the second in line for arguments for what this for interpretation of the Constitution.
Sure.
At least that's what it seemed like when I was talking to Sprouticus about this.
Sure.
So if you're going to do that,
Sprouticus is not your best constitutional argument. He's a constitutionalist. I'll give him that. He's somewhat conservative. I'll give him that. But
he's the one that got me looking into the Federalist Papers. That's why I brought him up.
No, the Federalist Papers are important, but they're not that you don't look at that and say, well, if I can't find justification, or if I can find something in Federalist 29 that remember, Hamilton he advocated, and he advocated all through the Adams administration. He advocated for a standing army. Of course, he was going to be against the militia, or he was going to say the militia had to be drilled and trained and whatever. Because he really wanted a standing federal army.
Yeah. So why is it that that the words of the Constitution, the way you read it, the way the Constitution is read, and the Federalist Papers, is a weaker argument to you than, well, this is what they were doing back then?
But it's not the only argument. There's the people that argued and wrote the Second Amendment argued against Hamilton.
Yeah, so like that's kind of like one of the flaws of this this philosophy of yours. In my view, is that you can look at what the founding fathers were saying, but the founding fathers largely disagreed with each other. That's why it wasn't like a one and done thing. That's why we had the Articles of Confederation first, because the founding fathers didn't agree on how the government should look. So, like, you're able to pick out the founding fathers that support you. I'm able to pick out the founding fathers that support me. You're probably able to do a better job at it because you've spent a lot more time researching this. But it seems like it doesn't really make a solid case.
Well, look, the Federalist Papers are a debate that occurred amongst the people, right? They were published in various state newspapers from New York to Philadelphia to Richmond. Okay, the different state capitals, large cities and stuff, because they wanted to affect perception of people, okay, toward or against the ratification of the Constitution generally. Okay, at the bottom line, Hamilton's arguments were not persuasive, okay, amongst the masses, because if it were, they would have gone back and they would have made specific reference to say that militias are government entities. But they weren't, because nobody thought of it that way. Here's another one. Let me add this. There is another component piece of this, right? That we sort of brush off, but everybody owned a firearm. Anybody that was anybody owned a firearm. A firearm was not a weapon of the wealthy. Maybe grape shot cannon and high fire weapons and stuff like that were the purview of the rich, or mortars were cannon were the purview of the rich. Okay, but basically you could buy a musket for next to nothing because it was as common as a hammer. Okay, so everybody who had it knew how to use it. They knew how to use it. The concept of being a well-regulated, you know what well-regulated militia means? They know how to march. They know how to stand in a line, because people, they'd line up, right? And they'd fire, and then the enemy would fire at them, and they would stand there. And training and drilling was about how to stand cool under fire. It wasn't about how to learn how to use a firearm. They already knew it. They grew up knowing it. Okay, and I think that's another piece that you kind of get hung up on. You have to understand a little bit more about Hamilton and what his machinations were. He fought Adams the entire way. He wanted war, right? He wanted war with England, okay? Because it would give the justification that he needed to be able to have a standing army. And Adams didn't want anything to do with it.
Okay, so the next part of this is going to be, is it Heller? Is Heller the Second Amendment decision in the Supreme Court?
Heller is one of them, yes.
That's the one for self-defense, right?
Mm-hmm. It's the DC case where DC said that you essentially couldn't take your handgun outside of your own home.
Yeah, so wouldn't that to you be the Supreme Court making laws, because there's nothing about self-defense as far as I know.
No.
Correct me if I'm wrong, in the Constitution.
Yeah, it is the right to life, liberty, and the pursuit of happiness. Your right to life includes an inherent right to self-defense. It's not inferred. It's not a substantive right. It is explicitly stated.
So the right to life, you could also be interpreted as the right for the government not to take your life.
Sure, and that's why you have a Second Amendment, so that you can resist the tyrannical nature of government.
But that doesn't necessarily mean that you have the right to carry a gun out for self-defense.
There was no federal prohibition on carrying firearms, so therefore anything that restricted the ability to carry firearms would be an abridgment, would it not? Or an infringement, sorry. I think it's appropriate to use the right word, so I apologize.
No, you're fine. I guess, yeah. So what is the definition to bear in your mind?
To hold in your possession.
Okay, so I've always read
to
it as
keep.
to
Well, to
own.
keep is to own. To bear is to carry.
Okay.
To bear, to bear in public. To keep upon your person.
Okay, I mean, I'll just have to take your word for that one for now, because, like I said.
Yeah, and if you can find a different definition in arcane language at the time of the founding, the ratification of the Bill of Rights, I'm happy to have that conversation with you, and we can talk more about it.
Okay, cool.
But Heller essentially finds the way that I said. It doesn't go as far as I said, but Heller says everybody, individuals have an inherent right of self-defense, and they have an inherent right to keep and bear arms. Now, there are other stuff that I think cases need to be brought forward to properly challenge them and get them overturned. The second half of the NFA 1934 needs to be overturned. And certainly there are significant issues with the Gun Control Act of 1968, as it has been amended multiple times.
Yeah, so I think I'm going to end my piece on this, and of course you can talk about it however long you want. By saying that I personally feel that Heller was creating laws out of thin air when it came to self-defense, because I'm still not convinced that the interpretation of the Second Amendment, where the interpretation of the Second Amendment is meant for individuals outside the service of a militia, is one that is the most accurate. That's just where I'm coming from still. Because like the argument that everyone had muskets at the time and everyone was training for the militia at the time isn't convincing enough for me, especially considering that there's like Federalist Papers that suggest otherwise.
What specifically in Federalist 29? What was Hamilton's specific argument?
It was something about the economy, I think, that because you can't have every individual being a part of the militia. You can't have every individual in the militia because they can't do other work. Furthermore, correct me if I'm wrong on this, because I'm sure you know more about it than I do. The Militia Act that was later passed, that defined what a militia was, didn't include women. Am I right about that?
Well, I mean, at the time, the only free people were white males.
Yeah, so if we're going by like a constitutionalist interpretation of this, because we have in tangent with the Militia Act, we're going by what they meant at the time.
Sure.
Then women shouldn't have the right to bear arms.
Sure, but that's superseded, right, by the 14th and 15th Amendments. Would you not agree?
I don't. What does the 15th Amendment say?
It gets to voting rights. Not voting rights for women specifically, but it's protection of voting rights. The 14th Amendment's one that said the laws apply equally to everybody. So the fact that it wasn't specified, or that people didn't vote, only landowners voted, but then they've changed federal law. That wasn't actually a constitutional issue that only white men that were landowners could vote. That was just federal law at the time. It wasn't necessarily unconstitutional. It's just the way they defined it, and then he changed the federal law, right? There was nothing inherently wrong for them to make the definition. But okay, so as the Constitution gets further amended, right, then...
So basically, like, the 15th Amendment gives women specifically the right to vote, but the 14th Amendment applies the law equally to everyone. So, like...
Yeah, they're generally considered equal protection, right?
So why wasn't it, and maybe this is just like them misinterpreting the why wasn't women given the right to vote after the 14th Amendment was passed?
Because historically women were considered property.
Yeah, well, so it's like, so with the Civil Rights Act, they gave black people the right to vote, right?
Women had the right to vote before 1965.
Okay, so why wasn't black people given the right to vote?
They were given the right
with the 14th Amendment, 15th Amendment.
They were given the right to vote with the 13th Amendment, or actually they were free. They were freed. They were free with the 13th. They were not to be mistreated by the 14th, and the 15th guaranteed their right to vote.
The 15th Amendment guaranteed the right to vote.
I think I feel like I need to double check myself.
Okay. I mean, it could be just the case that it should have, but it just wasn't because the Constitution wasn't being interpreted properly.
Well, no, that's fair, right? That's pretty fair, because we saw a lot of things that went on. A lot of Jim Crow existed because of faulty logical reasoning, right? And it was there were attempts made to correct that with, like, say, the Civil Rights Act of 1965. Okay, the rights were guaranteed by the Constitution, but there was no federal law, no punishment, because the court says, here's my thing, okay, unless there's a criminal law that prohibits the activity and provides punishment for violation thereto, nothing actually was a deterrent to prevent people from having their rights still abused. So the Civil Rights Act comes along and codifies what the law means, and then what the punishments are for violations, and it provides for civil and criminal activity, including oversight. Like the federal government can come in and provide oversight against states who change their voting, the way that they do their presidential selection for electors or the voting laws, if they had a historical pattern of discrimination, right? Intentional discrimination. And we saw this a lot in the South. As a matter of fact, most of the civil rights cases since 1965 were brought against Southern Democratic governors. Okay, democratically led states. So the fact that the Constitution says that you have the right to do X doesn't prevent the federal government or state governments from continuing to abuse those rights. You just have redress capability for your grievance. And then, of course, if the federal government actually gets off their ass and codifies certain segments of the law, then you can provide active punishments which serve as both a protection, a further protection, and then also a punishment for people who aggrieve others.
So real quick, the 15th Amendment was voting rights for African Americans. The 19th Amendment was voting rights for women.
Yeah, I wasn't talking about voting rights for women specifically. It is one of those early amendments. I knew it was after.
So if it was the case that that the 14th Amendment, oh gosh, okay. If it's the case that the
14th Amendment should have guaranteed the right to vote
to women, but we needed another amendment to do that. Why is that?
Because women were still seen as chattel property.
Do you think that maybe perhaps they didn't interpret the 14th Amendment in that way?
Oh, I'm sorry. Are you side shifting the argument away from what the 14th Amendment was for? Because it literally applied only to blacks on previous condition of servitude as part of the language.
My understanding of your interpretation of the 14th Amendment is that it basically guarantees the rights of the Constitution to everybody,
regardless of previous condition of servitude. It was specific. This is where a lot of people get lost. The 14th Amendment was specifically limited to former slaves.
Okay, I got you. All right, so I just misunderstood what you were saying before.
No, what has since happened is that various Supreme Court cases have said that the 14th Amendment applies uniquely to everybody, and that's why it's uniformly called the equal protection. Right? Everybody's rights are equally protected. You cannot treat one group of people in this country different based on things that have come forward in federal law, like race, gender. I guess you can treat people differently based on political ideology. We see that all the time, right? On both sides of the coin. But everybody is supposed to be treated fairly and evenly. And oddly enough, a 14th Amendment case came before the Supreme Court. They had oral arguments, I think, today or yesterday, and Ketanji Brown Jackson is actually advocating, that the 14th Amendment was designed to solve a problem inherently race-based. But that's not what it was. The fact that former slaves were 99% African American didn't matter. The 14th Amendment said no person shall be denied the protection of the laws of the United States regardless of previous condition of servitude. If you were a slave or an indentured servant, you had the same rights as everybody else.
So let me ask you this. So the 14th Amendment is narrowly tailored to people who used to be slaves.
As it was written, yes. I think there's been court cases that have broadened that interpretation.
Yeah. So, but you wouldn't agree with that that broadening of the interpretation, correct? Like, because that'd be against your constitutional constructionist views, right?
So this is good. See, you might have thought you have found yourself a way to trap me in my own logical prison.
No, I'm trying to understand.
But the 14th Amendment here, let me pull it up so I can look at it specifically. So I know these things, right? But then you want to go back and if you want to argue specifics, then you have to look at specifics. And then this might be something that requires a little bit of in-depth analysis, right? And then a follow-up conversation for some of these things, because it's a good point, right? If it says it's supposed to apply to everybody, regardless of previous condition of servitude, that's a pretty narrow definition. Why, in fact, is it broader? Why is it more broadly applied today? And I think largely the reason for it is that the Supreme Court has held in precedent in other cases that the 14th Amendment applies in these other areas. Think the holding up of Title IX, for example. Okay. And then the inferred right of equal protection based on gender, which I think was I can't remember the case, but it was one of the big cases that Ruth Bader Ginsburg made her bones on before she became a Supreme Court justice. So as I look at this, it says all persons born or naturalized in the United States are subject to the jurisdiction thereof, are citizens of the United States and of the state in which they reside. No state may make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within its jurisdiction the equal protection of the law. So that's kind of interesting.
So it doesn't sound like it was tailored to previous servants.
Hang on one second. There's a historical background here. Tick, 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 tick.
Hey, I'm going to use the bathroom real quick.
Yeah, go ahead. Go ahead, because I want to read this real quick. Section 2, representatives shall be apportioned among the several states according to their respective numbers, counting the whole number of persons in each state, excluding Indians not taxed. This is interesting because even they said everybody, and they still called out a lot. They called Indians not taxed as a specific group of people. Right to vote, when the right to vote at any election, the choice of electors, president, vice president of the United States, the executive members, is denied to any of the male inhabitants of such state, being 21 years and citizens of the United States, or in any way abridged except for the participation in rebellion or any crime. This is the one that they're trying to hang on January 6th on Donald Trump. The apportionment is based on the whole number of male citizens 21 years of age in each such state. So they still didn't, even in that amendment, even though they said it pertains to everybody, the apportionment excluded women, which were like 35% of the population. Interesting.
All right, I'm back.
Yeah, so there's in section 2 of that article, of that amendment, they talk about apportionment of representation in the House is being limited to those who are 21 years of age and older who are males. Nothing about females, whatever. So even in that amendment, right, there's a specific exclusion for women, which were, I think, 30-ish%, 35%-ish of the population at the time.
Wait, could you repeat that or maybe rephrase it because I didn't understand?
Okay, representation in Congress is part out of Section 2, the apportionment of representation. Representation of Congress. Oh, sorry. When the right of any election choice for president, the executive and judicial officers state blah 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 is denied any of. Okay, so when the right to vote at any election for the choice of presidential electors or vice president of the United States or the representative Congress, executive or judicial officers of a state or the members of the legislature of the state is denied to any male inhabitant of such state being 21 years of age and citizen of the United States or in any way abridged except for the participation of rebellion or other crimes. So this is the one they want to hang Trump with, right? Which January 6th, he said he participated in a rebellion. He's therefore ineligible for office. He's ineligible to vote. That's the one they're trying to do. It said the basis of representation, meaning the apportionment, the number of representatives that are apportioned to a state population, shall therein be reduced to in proportion to the number of such males, citizens that bear the number of the whole. Basically, you subtract out the people that were guilty of rebellion, who are over 21, and everybody else that's over 21 is the number that you use to target your apportionment. But it's males 21 years in age and 21 years of age and over. So, yeah. So, I believe it's the 13th amendment that was the issue of previous condition of servitude. Because it's a specific phrase and it sticks in my mind.
Okay, I'll let you look at that.
Yeah, so anyway, but more broadly speaking, whether you agree with it, and there's a lot of Supreme Court precedent I disagree with. There's a lot of Supreme Court precedent I'm sure you disagree with. You stated Heller is one. I'm sure you found.
To be clear, real quick, I don't disagree with Heller. I just think that it was kind of making up interpretations of the Constitution.
Well, if it makes up
making up laws.
Okay.
Because I'm not a constitutional constructionist, so I'm okay with that.
You're okay with the Supreme Court making law?
I guess I'm okay with the Supreme Court interpreting these things in ways that could have other implications.
Okay, well you're kind of dodging my question a little bit there.
I mean, I guess if you want to interpret that as making law, but I don't think that the Supreme Court should go outside of the bounds of what is said inside the Constitution. So something like Roe, I think that was probably a bad interpretation of, even though I like the right to abortion, that was probably a bad interpretation of that amendment. But there's other things to that makes it more okay to me that we can get into if you'd like. But it kind of gets into my views of the flaws of government as we have it right now.
Well, I mean, I think, we could try to argue the Constitution all day long, right? But I don't think it's going to change much. I think you're what you just said, you're trying to kind of have your cake and eat it too, right? You don't think they should make laws necessarily, but the fact that they did something, even if they did it in a legally imprecise or imperfect way, if it results in an outcome that you like, in this case, say the right to abortion, for example, you're okay with that. You're okay with the faulty logic ending up with an outcome that you like.
Yeah, so the only reason that is the case is because I believe that the legislator is kind of broken right now. If the legislator wasn't as broken as it is, I think that we'd be able to pass these laws in order to where we don't have it necessary for things like Roe to be a thing. I don't like that we have a system where we have to have like the Supreme Court protect the right to abortion to all American women. But I think that that's kind of the system that we found ourselves in, and there needs to be changes to the legislator that changes that, so that we can have a Supreme Court that doesn't need to step up to protect these rights.
Yeah, I would agree with you in principle that if the laws were written better, more clearly, and that they comported with the Constitution, that the Supreme Court's job would be a hell of a lot easier, right?
Yeah, and I'm speaking specifically like the filibuster. I feel like the filibuster stops things.
Well, there's a reason. There's a reason it stops things.
I understand that, but I think that it's more damaging than it does good.
Right. So the thing that makes the filibuster problematic, and oddly enough, did you argue that the filibuster was bad when the Democrats were in the minority? Did you ever make a public comment that the filibuster should be eliminated when? I'm sorry, when when they were in the minority, when they were able to successfully block 300 and some odd bills from advancing?
So I was I didn't become politically aware until 2008, but that wasn't even that was like scratching the surface. That was like watching Jon Stewart, politically aware. I didn't become politically engaged until 2016, but I wasn't I was really into I wasn't as knowledgeable as I was. Okay. So I was like the filibuster wasn't even a thing that was on my radar until until I started looking into it recently, specifically around ACA and why we didn't get a public option.
We didn't get a public option because not enough senators would vote for it. It had nothing to do.
Well, it was filibustered.
They could not. They wouldn't have gotten 50 votes.
No, I think they wouldn't get I might be wrong. I have to look into this, but I think that it was that they couldn't get enough votes to break a filibuster.
So, do you know the historical significance of the filibuster? Why?
Okay, so I don't know what your version of facts are, but from what
I'll just tell you the history. I'm not going to facts or history. I mean, there's two ways of looking at history. You can either look at it as a purely historical, this thing happened, or you can look at it like presentism, right? Where you say, okay, this thing happened and it's morally bad because today we look at things and say that this is morally bad, right? People look at slavery was legal. It was constitutionally permitted, okay? But presentism looks at the issue of slavery and says, that's bad. Everything that's associated with that in history, bad, wipe it off the face of the earth. Historicism says, slavery existed. It was constitutional. It led to a lot of problems in the country. We fought a civil war over it, and we've struggled mightily trying to correct the issues that were associated with lay out the facts of what happened, and then you can save the historical representation about the what ifs for like an elevated discussion within a history class or a philosophy class, right? But today, we see a lot of people who are on the left-hand side of the aisle believe that we need to judge the past based on today's mores. And that's an insane way to try to figure out how you're going to live your life, because you are willing to just cast aside everything good and bad that happened in history. It's like people want to take University of Virginia wants to take off Jefferson's name off the building. It's a land grant school that he gave them. He gave the state of Virginia, the University of Virginia.
Yeah. Real quick. So my understanding of the filibuster is that it was implemented because the people who implemented it, was it Thomas Jefferson? Yes or no?
It goes back to the early days of the Senate.
Okay, so
the reason is that
debate was good.
They thought debate was good. They also the Senate was a body of equal deliberative authority. Every state had 2 senators appointed by their legislature. That was the original Constitution. The House was apportioned, so you had districts, and there were 35 or 40,000 people, and per representative, and then they went in and they were more closely aligned to their district, their voter, right? So it's more of a democratic process to elect your representative who is more beholden to you and your geographical area. The Senate was supposed to represent, in the federal republic, the Senate is supposed to represent the interests of the states. Remember, the states at the time were sovereign entities. They were in a voluntary association called the United States of America, and they were sovereign states within a republican form of government, right, under a federal system. So the federal government wanted to ensure that everybody had certain rights and privileges, but then also states had some rights. So the states legislatures, they elected the local people, they elected their state legislature to represent the interests of Georgia, of Virginia, of California, of whatever. Okay. And then the idea is that the House was going to be more responsive to the needs of the people, but the Senate needed to be responsive to the needs of the state, of the several states. And that the conflict or the debate that would exist between those sometimes conflicting bodies, okay, would lead to a consensus approach towards how the federal government would work. The founders didn't want a partisan whipsaw going back and forth with political parties changing every few years. And I mean, they hated political parties. George Washington spoke famously about it. Okay. He thought the political parties would be the end of the republic. But they come down and they said, okay, the House says, I want everything. And the Senate says, well, we can't do that. It's not in the interest of Georgia to do it. And instead of having, like we do today with basically population derivative stuff, you have big population states that happened in this case to be on the coasts, that if you didn't have a filibuster or you didn't have the Electoral College, these states in the middle of the country would have basically no political power. They would just be victims of whatever the tyranny of the majority of people were. I don't know that answers your question, but so the filibuster was that there, in order to get something out of the Senate, you had to have a majority, a pretty good majority of people to advance it forward. Now, once you said, yeah, to say we want to end debate. Now, after that, you still only had to have a majority to pass the bill. You just had to have 6/10 of the Senate on board with advancing it to the final vote. And that's what the filibuster is.
Yeah. So, was the filibuster ever meant to be able to obstruct bills from passing that had a majority of Senate? Like was that ever meant to be? Was it ever meant to be used in that way?
I think it has been used that way by both parties.
Well, yeah, that's how it's been used. But was that the original purpose?
No.
Okay. So would you be okay if we brought the talking filibuster back instead of getting rid of filibuster altogether, but we made it a talking filibuster?
I think the rules of the Senate are the rules of the Senate. I think I think a lot of the problems that we see in the filibuster, where a lot of people, especially on the left, get upset with this, is they were totally okay. They were totally okay when Harry Reid eliminated the filibuster for federal appointees, for federal appointees, including federal judges. And then Barack Obama put 300 pretty radical left-handed left-handed sounds pretty bad. Yeah, they wrote with their left hand. Left-wing ideologically oriented judges and justices on various courts in the United States. And he said, "Oh, don't worry about it. We won't do that to the Supreme Court. That's the last line too far, right?" But then Mitch McConnell gets in, and then they turn around, they do the same thing. And now, right, the Democratic Party is, they're talking out of both sides of their mouth. They love the filibuster when they're in the minority, and they hate it when the Republicans are in the minority. They hate it. And they use opposite arguments, right? They said that it was racist to do it. Okay, yet persons of color have executed on the filibuster when they were in the Democratic minority. So it either is or it isn't. I think the filibuster is the only. What I would love to see is that we repeal the 17th Amendment, and that we send the appointment of senators back to the states, so that Kentucky and California and West Virginia and New York and California all have their own ability to send the senators that they want. And if they want to send 2 Democratic senators, let them send 2 Democratic senators. If you want to send a Democrat and a Republican or whatever.
Is the 17th Amendment the one that gives people the right to vote for their Senate?
Yep.
Oh, yeah, no, I'm absolutely against your idea, because I think that democracy is one of the...
We don't live in a democracy, my friend.
Yeah, well, okay. I think that the democratic aspects of our institutions is what gives it the most legitimacy in most people's eyes.
But you think that because they're, well, you would, okay. So you would be okay with a 51% majority in the House and a 51% majority in the Senate, saying that nobody should make over $100,000 a year, and then we will tax everything above that.
Yes, because I don't think that anybody that wants to keep their job in the House and the Senate is going to vote to tax 100% over $100,000 a year.
You don't think so? You know what the marginal tax rate was in 1962?
It was like 90 something, but was that over 100,000?
No, it was if you made over, I think it was over 100,000 or something like that. Yeah, but it was massive.
I mean, I would have to look that up.
It was massive. And Kennedy came into office, a Democrat. He cut the taxes. He cut them massively. And then he also cut the size of government. Donald Trump, the tax cuts that went in 2019, 2017, and 2019 was the first year that they showed, like, what is the effect of it. The amount of money the federal government took in income tax in 2019 was the highest it had ever been. Yet we still operated at a $1+ trillion deficit. Why do you think that is?
Hold on 2 seconds. I'm looking this up real quick just because I want to know.
And by the way, the reason why the filibuster still exists, any senator that votes to do away with it will be most likely voted out of office. It'll be pretty massive. Or you're going to see what I would love to see, which is a convention of states.
The filibuster, I think, is only popular on the right.
Okay, go back and look at what happened when Chucky Schumer was in the minority under Donald Trump for the first 2 years.
Yeah,
see how many times
the filibuster is popular for any party that's not out of power. I'm sure that there are things.
Any party out of power.
Yeah, any party out of power probably doesn't like the filibuster.
You know what it does? You know why? You know why it's important for them? Because it gives them leverage to negotiate. Now that's what it intentionally was for in the beginning, right? It was meant to force senators to dialogue and discuss and try to convince each other. What we have now with our modern political system is that we basically berate each other. Chuck Schumer goes out and stands in front of the Supreme Court and says, "You'll weep the whirlwind, and we're going to do this." And these guys, they're evil. They want to push grandma over a cliff. That's not really what's going on. And most of the time that people vote against bills, it's because there's something in the bill. They'll say, well, we're going to lower insulin costs. We're going to make it $35. Oh, and by the way, here's this other chunk of legislation in the other side that's going to transfer, $2.2 trillion of wealth that we're actually just going to sort of print a bunch of money, and we're going to send a bunch of checks out to people and let them sit on their backsides playing YouTube and YouTube video games and talking to political talk shit on Twitch, right? Like we're doing right now, right? I mean, I still have a job, so this is my evening gig.
So real quick, the top marginal tax rate in 1962 was $200,000. That was the 90%, but that's worth $1,961,397 in today's dollars. So, yeah, I honestly wouldn't mind taxing people who make over that amount of money, 90%.
What do you think if you give people an absolute limit to their income, which is essentially what that does, would you argue?
No, because
it's pretty
90%.
Well, I mean, who's gonna?
It's pretty.
Who wants to work?
Harsh tax.
Tell you what, you got $10 in your pocket, give me 9. And every time you get $10, give me 9. How often, or how long do you think it takes the person who's making that kind of money through innovation, through whatever, right? Through a capital expansion, through they built a better mousetrap. What do you think? Well, I could make more mousetraps, but I just don't see the reason to risk all this capital for a 10% net negative gain, because that's what would happen.
Yeah. So anybody that's making around $2 million a year, probably, my guess would be, has a job that's going to require them to keep growing in order to keep that job. And if they don't do that, they're going to lose that $2 million job.
Right. So maybe they just take their $2 million they've already got in the bank and they just say, fuck it, I'm done. I'm just going to go, buy a boat and then go troll around the Gulf of Mexico for the rest of my life.
Possibly. Or maybe they're going to want to make another $2 million next year.
See, I think class envy is you're making an advocation for class envy, right? People who don't have it are okay with taking it away from someone else. Like I don't care. I don't know what you make for a living, right? And I don't care. You could be a multimillionaire who just likes, chatting on Twitch political TV and on Twitter. It doesn't really matter to me. What you make doesn't affect me. Okay, but people on the left say that, well, okay, I make a 6-figure salary, but I've also been working for 35 years and I've added skills to my set and I have a lot of talent and I bring value to the companies that I work for. Okay, but there are a lot of people on the left who would say, well, you don't deserve that. You don't deserve it. Your work isn't worth as much as your work would be better well used if we take your income, your wealth, and we redistribute it out here to these other people, because we can help these other people, some of whom choose not to even help themselves.
Yeah, so my philosophy around this isn't class envy. I don't care that people are rich. My philosophy around this is that I'm looking for a floor of quality of life to the best of our ability as a society. And I think that we can do much better, but we need resources. And I think those resources should come from the top. It doesn't have to be 90% after 2 million. I want whatever it takes to get, like you said earlier.
Yeah, it's not the number. It's not the number, right? It's not the number that matters. It's the concept. To say that you think that it's okay to take something from somebody who earned it, who worked, who tried to contribute to society, and give it to somebody else who may not even give a shit about contributing to society. And that really goes against the fabric of what this nation was built upon, which was like, our nation was created so that people would have enough freedom to use their God-given talents in such way as that they could make their way in the world and get whatever success that they could achieve. And you're okay with saying, not everybody's equal, and we're going to try to level set the playing field by redistributing some of this money, whatever that number is. We hear on the left all the time, we hear comments about, well, we're going to provide this redistributive economics program because people need this floor of this minimum floor of existence. If you didn't have a minimum floor of existence, one of the biggest things that leads to income inequality, if you look at income inequality from 1945 until 1968, you'll see that there was some gaps between the races, but generally speaking, as whites increased their wealth over time, blacks and Asians and Hispanics also raised their income. They kind of tracked pretty well together. It's not, in fact, until after 10 to 15 years of the Great Societies programs with welfare and affirmative action and all these other programs that were brought about by Lyndon Johnson's administration, that by 1980, you begin to see this massive delta beginning to form. And that's because you've had now 2 generations, the second generation of people who were forced into inner city housing in big urban cities. And then when there's a large economic downturn like there was in 1981, 1979, 1980, 81, 73, 74, 79, 80, 81, you have those recessions. Then all of these people who are now in this tightly compressed space are fighting for ever fewer jobs. So you have massive unemployment. And then prices went up because that's what they did because of the oil crisis, stagflation. If you don't know what it is, it's a pretty interesting concept. Take a look at it. I was an economics major in college, so we could talk about it all day long if you wanted. But these crises, right, exist now because we basically created a system where we said, oh, all the poor people, if you come in here and you don't have enough, we're going to give you a floor to your existence. We're going to give you a handout. We're going to give you welfare. And then eventually a portion of the people who were taking the welfare decided that they could live on welfare. Oh, and then we've also made it problematic because if you tried to get a job, we would reduce your welfare. So what they did is they turned to other means. They started selling drugs, prostitution, things like that. And they ran cash economies underground. Of course, when they get caught selling drugs, Joe Biden's, crime bill, 1994, begins to separate a significant number of African-American fathers from their children. And now you have the third and the fourth generation of people living in the inner city who are now basically bred, for lack of a better word, institutionally poor. And then we have the whole CRT thing where it says, well, if you don't give me reparations, I can't get ahead because I'm starting so far back. So I need more reparations, which, oh, by the way, I need more tax money to do this. And therefore, I need to pull everything else apart so that I can, find my way out of everything that I want to do. But guess what? Reparations don't do anything for anybody. Oprah Winfrey had a program in the 80s. She had her TV show in the 80s. She had a program. She was going to give $1 million to some number of people. And she was going to track them for a year to see how they did. She cut the program off at 10 years because everybody who had the money went out and blew it on luxury items, and then they still had still living in the same crap hole place to live, and they're doing the same thing, and they just simply blew it all. It's like, the story of what happens with most people who win the lottery, right? They end up financially worse off than they were before they won the lottery.
Okay, so one thing I will say is you brought up a point about welfare and the way it's designed. That's absolutely true, and that is that it does discourage the people getting jobs, people getting raises and stuff. But that's only because of the way that our specific welfare system is set up. I think that we can set up our welfare system in a way that doesn't discourage such activities, which would be a whole lot better.
You mean like we did in 1995?
I can go on and talk about some of the other things that you mentioned, or would you prefer to just kind of drill in on that point?
Well, let's drill one little point, and then we can move to the next one. But you said that we could set up our welfare.
I don't have that much time because my friend's on the way back, and I'm going to stop this when she gets back and spend time with her.
Well, whatever you want to do, man.
Yeah, so we may have to rain check our conversation, but we can go ahead and start it right now.
Yeah, that's fine. So I would just say that the issue of how welfare is constructed, I'm glad that you agree with the way that it was constructed, you know, as it came out of 1968, 1965, 1968, and 1969 law. The Republicans took over the House with Newt Gingrich, and they swept through, and they had this thing everybody uniformly called the Contract with America. And basically it created a welfare to work program. You were going to get, if you were getting welfare, you had 2 years to learn some kind of a skill or get into college or get into some schooling or training. And if you were doing those things, if you were looking for work or you were in school or you were otherwise engaged, then you would end up with something that gives you the ability to keep making welfare while you were continuing to improve your stuff. Because the idea was that we wanted people to get themselves to a skill position where they would be off of welfare, right? Under that program, more people left the welfare rolls than had ever done before. And it was a fundamental change of philosophy compared to the way the Democrats said that no matter what the circumstances were, if you were at this income level, you got welfare. If you were not at that income level, it was very black and white. If you were not at that welfare level, you got nothing. Okay? And that discouraged people from working. The Republicans had a good plan for that. Barack Obama killed it in 2009.
So I would have to look at the history behind welfare to work programs and see how effective they were.
Take a look at the Contract with America, and then also look at what Barack Obama did when he came into office, because he basically killed the work requirement for welfare, and then you just end up seeing more people. There were 47 million more people on food stamps in 2015 than were in 2008. And that's with the Democratic majority, his Senate, House, and a White House.
So something I would want to see as a reform is we have a system that if you make an extra $1, you can lose $400. I don't know what the actual numbers are, but like a system that's like that with welfare. What I would like to see is if you make an extra $1, you maybe lose 75 cents. That's going to encourage people to make that extra $1 while weaning them off of welfare much more in a much painless way that doesn't discourage.
Yeah, take a look at the Contract with America. That did exactly that. It gave people a sliding scale so that they could continue to get benefits, particularly like if you're working, you're a single parent, being able to work and be able to afford childcare and have some kind of a subsidy for your childcare. That was very important. It was part of the Contract with America. Okay. But when Obama removed the requirement to work in order to get welfare, all of that stuff went away. So people were no longer incentivized to actually improve their circumstance to get off of welfare. Millions and millions and millions of people left the welfare rolls under the Contract with America, and their lives improved. Not just like they were kicked off and then had nowhere to go. Their lives measurably improved. And the Democratic Party, who needs people to be at a certain level of poorness so that they can justify the diatribe that says, if you vote for the other guy, he's gonna take away what we give you. But they only give you just enough to make you dependent on what they give you. And there is a core philosophical, fundamental political economy belief that if you give people just enough that they can survive, a lot of those people will, human nature is what it is, a lot of those people will do exactly what they need to do to survive, and then they will do other things that may or may not be outside the bounds of legal propriety in order to make up the difference. And that's exactly what happened.
So you made a claim. There's so much. You made a claim earlier about like people.
We can do this as a weekly series if you want. That's fine. Pick a topic and then we'll just deep dive a topic.
I'm definitely interested in talking to you more. I don't know if I can commit to a weekly series. The reason why I don't play
No,
Dungeons
monthly,
and Dragons is
whatever. I mean, just whatever, whenever the mood strikes. I'm
yeah,
flexible.
So
Well,
really,
I mean, you look at me and you think, well, how flexible are you really?
so I don't agree that again, this is something I'd have to look into, but my intuition is telling me that the shoot, the thing that you, oh gosh, what's it called when you don't say something but it's kind of, the implication that that you made earlier, that like people were selling drugs so that they can make extra money while staying on welfare. I don't know that that's true. I would have to look
It's
it up.
absolutely true. I'll tell you what. I'll look up the stat and I'll send it to you on Twitter.
Okay, so I would have to look that up. Give me 30 seconds. I'm somebody called me.
Yeah, no, that's fine, brother. All right. Let me catch up here with chat. Hey guys, thanks very much for coming to hang out. I know all 7 of you. We were up to 11. If you haven't used your Twitch Prime Gaming subscription, do me a favor. Daddy spent a lot of time reworking his platform, so
Real quick,
I need the money.
I know you're doing your thing, but my friend's outside, and I forgot that she's like locked out without me going to get her. So
whoa! Did you build a wall around your house?
No, I have her keys. She let me into her house.
I'm teasing.
Yeah.
Okay, so go ahead and give yourself a quick shout out, and then we'll pick it up another time.
Okay, yeah, I'll hit you up on Twitter. I'm LiberalCluck. I'm much more interested in a conversation than the following. That's why I'm here talking to More Perfect Union. If you want to talk to me, just hit me up on Twitter or Discord.
Okay, man. Thanks very much. I do appreciate it so much. Have yourself a good one, and we'll catch up with you later, brother.
You too, Bobby.
All right. And that was the Liberal Cluck.